of the NAPSIPAC Disaster Research Group, I welcome you all to the first discussion as part of the NDRG lecture series on frivolous litigation and executive accountability to the Constitution. NAPSIPAC Disaster Research Group is a specialized body of NAPSIPAC network of Asia Pacific schools and institutes of public administration and governance that was set up in the year 2004. It owes its origin to NAPSIPAC researchers in law and governance who discovered the need for transdisciplinary interaction with practitioners in law, administration, natural sciences, e-governance, and artificial intelligence to prevent and mitigate disasters. To trigger today's discussion on frivolous litigation and executive accountability to the Constitution, we have two extremely eminent speakers with us today, Dr. Nivedita P. Haran and Dr. Puneet. Dr. Nivedita P. Haran has more than 3 decades of experience as an administrator and has also served as the Additional Chief Secretary in the Department of Home Affairs, Government of Kerala. She has also been instrumental in setting up the Disaster Management Department and State Disaster Management Authority in Kerala. Welcome, ma'am. We also have with us Dr. P. Puneet, who is an associate professor at the Center for the Study of Law and Governance, Jawaharlal Nehru University, and has also been associated with Indian Law Institute, New Delhi. I also take the privilege of welcoming Dr. Kokila Konasinghe, who is a senior professor in the University of Colombo, Sri Lanka. I now take the privilege of formally welcoming the chair of today's session, Professor Madhusri Shekhar, who is a professor at the Tata Institute of Social Sciences and is also the Dean of International Relations Office and the Dean of Vocational Education at the Tata Institute of Social Sciences. I now invite Professor Madhusri Shekhar to start the proceedings of today's discussion.
Thank you, Gaurika. Thank you very much. It's my privilege to chair this session and be part of this very excellent program that has been conceived by NAPSIPAC Disaster Research Group. And we have this today's talk as Gaurika has mentioned, that it's on frivolous litigation and executive accountability to the Constitution. And this is, as we are all aware of, this a very, very important topic. And today in today's world where there's no end to the supply of cases that seem too big for courts, and cases that seem too small, and cases that should never have been cases at all. At one end of the spectrum, we have number of mega suits that have ambled along, that have gone along for decades and are being in the litigation space, and then also and then on the other side of the spectrum, we also have many trivial suits, pursue trivial cases that can go to and what our theme of the topic today is on, and understanding is how these frivolous cases and litigations are crowding our courts. And in this space, what is executive accountability to the Constitution? For this talk, I have the honor and the privilege to welcome our most esteemed speakers for this talk. Without much taking time from hearing the three speakers we have got with us, I'd first like to welcome Dr. Nivedita Haran. She, as Gaurika has briefly introduced, I'll just give her a little introduction about what Dr. Haran's work has been and what she has really done. She has graduated with economics and philosophy and has obtained a master's in philosophy from Jadavpur University and a PhD in sociology from IIT Delhi. She joined the Indian Administrative Service in 1980 and worked in the state of Kerala and in the government of India in various departments that included departments of land revenue, disaster management, agriculture, industries, and a number of other departments. She was director and later joined as joint secretary in the Ministry of Urban Development, Government of India. She was on deputation to the UN peacekeeping mission in Kosovo for 5 years. Post-retirement, she has been engaged in activities related to research and academics in the area of disaster resilience building, good governance, digitization of land records, labor camps, migration issues, management of water, wastewater, and solid waste. She is a member of the core appointed committee of experts for cleaning up and conservation of Dal Lake and the committee related to modernization of land records in Delhi. She is also the chairperson of the Center for Migration and Inclusive Development and the Bhumi Trust. She has been a regular speaker at various training institutes, including the Civil Services Training Academy at Missouri. Ma'am, we are honored to have you here with us and look forward to hearing you.
Thank you. Thank you, Professor Madhushri.
Thank you, ma'am.
Good morning to all of you. I have a brief PPT which is now visible. It's indeed an honor to participate in this NDRG program, and one of the first lectures that NDRG is arranging. And I'm really, really thankful to the entire team at NDRG, as well as, of course, led by Professor Amita Singh and all the young researchers and scholars who are part of it. NDRG is close to my heart because it has a huge potential. It's a conglomeration of social and natural scientists on the one hand, who are not only academicians, but also thinkers, who think and research beyond their mere boundaries of discipline. It is also important for me because it is one of the few forums, one of the few fora that bring together academicians, researchers, and civil servants, along with technocrats, along with the non-state actors, NGOs, activists, and so on. So it's a multifaceted fora, which is not a forum, which is not limited to any particular discipline, and therefore it really attracts my interest and my attention. My presentation is based on my knowledge and experience. It is not meant to criticize or belittle anyone, but then I'm going to raise some issues, and I'm going to raise them because I know that I have the years of researchers and scholars, and I would like them to spend some time thinking about it, and also to take up studies, to take up research projects, which would probably be beneficial to not only to the academic community, but also to the public servants. So as in Kantian words, I present as I saw them. And therefore you are free to differ from me, but then I would like you to give me a year. Frivolous litigation and executive accountability. What is the executive? The executive, which is variously called the backbone, the steel frame, the rubber stamp, is the professional. I think, Gaurika, can you change the slide? It is the abiding executive that is called the public servant, that provides the public service. In a parliamentary democracy, the responsibility to run the government is on the elected representatives because they are answerable to the people. But with each election, the ruling party may change. There is a possibility of change. Ministers change. Even the minister's officers change. And therefore, what provides the continuity is the civil service. Article 312, we all know this, you are scholars. It provides the basic outline of the Parliament's authority to set up the All India services and the central services. So roughly, I picked up these figures from my Mussoorie Academy. There is, as far as higher level civil servants are concerned, there is one for every 27,000 citizens, and this includes not just the IAS, IPS, and IFS, Forest Service, but which are the All India services, the three of them, but all the central services. I think there are 29 or 30 of them, revenue services, foreign service, income tax, etc., statistical service, etc., etc. And if you count all public servants, which includes municipalities, every level, then for every 200 person in our country, there is one public servant. That is the ratio that we come across. Let me move to the next slide. What is the role of the civil servants? Civil servants are the policy formulators. You may immediately say, what does the political executive do? Well, in actual fact, a politician who comes in and a first-time minister knows very little of what exactly are the requirements. All that he has is his manifesto, his party manifesto. And often the manifesto is never even opened in our country. So the policy formulation most often is done by the executive. They devise the plan, they prepare the budget. They also implement the projects that flow from these policies. They collect the funds, which pays you and me. And for every project, developmental and otherwise, they are the revenue collectors. They maintain law and order. The police does, and so do many other authorities. They also enforce accountability. Whether it is the CBC or the CBI, it's done by the public servants. And to do this, they have the protection of Article 311, which says that every civil servant is protected from politically motivated or vindictive action. And the civil servants, the higher civil servants, and that flows up to the lower level, serve at the pleasure of the President of India, the highest body, the highest authority in our country. In the next slide, I would like to bring out the conflicts that arise between ministries, departments, as these civil servants function. When they have to deal with a gamut of areas and sectors, there are bound to be contrary or conflicting policies or practices. It's not surprising. You just think of it. The civil servants, on the one hand, is developing industries, encouraging industries, and on the other, he or she is also making policies to protect the environment. At some stage, at some point, they are bound to come into conflict. How these conflicts are resolved, I'll come to presently, but I want to first reinforce the fact that conflicts are inevitable. Protection of water bodies and reclamation of land. On the one hand, we are reclaiming our old ponds and tanks that existed in the past because land is so much in demand. And on the other hand, we have a water supply and irrigation department that is meant to protect those water bodies. Now, how do you combine the two? It does happen. It happens not only at the lowest level where the projects are being implemented, but it happens even at the policy level. How do you sort those out? This is evident from contrary affidavits that are often filed in the court cases. I have a lot of examples in mind that come to my mind. I remember a case where it pertained to the Cardamom Hill Reserve area in Kerala, and continuously the Forest Department and the Land Revenue Department were filing contradictory affidavits before the High Court. And nobody was even noticing it because, as I go on to say, that affidavits are very often not even seen at the highest level. They don't go above the level of the section officer very often. This is also evident when a ministry or department is has approached the court for finding a solution. So not only does it happen by default, but it also happens willfully when a department or a ministry goes to the court, whether it is the High Court or the Supreme Court, requesting that the problem may be sorted out, to discuss and to adjudicate between central ministries or departments. Now, finding this kind of contradiction or contrariness that often happen actually more often than you can imagine, the government of India has actually nominated a secretary. He's called Secretary Coordination. He or she is called Secretary Coordination, who is part of the Cabinet Secretariat, who is supposed to be discussing, finding out, and adjudicating between central ministries, different ministries in the center, or between the center and the state, or between the states, two different states, between Karnataka, Kerala, between UP and Bihar, which may happen. For issue-based disputes, there are often tribunals. We know of tribunals that are existing in our country. There are a number of them, whether it is the sharing of river water or boundary disputes or even language disputes, whether the official language in a certain area, in a certain boundary area of a state should be Marathi or Konkani. This kind of disputes are often assigned to tribunals, and they try to find solutions. Yet, even in such disputes, even when the tribunal adjudicates and gives a final order, the states prefer to go up to the highest level, up to the apex court. And that obviously can delay matters no end. And it is done. I'm not going to go into the modalities of it or take examples, because I think a lot of them may come to your mind. These are done for political reasons or for administrative reasons, to make a point that even though the tribunal has adjudicated against me in a state, I would like to take it up to the apex court to find out if there is chance of my succeeding. Next. Hiding behind numbers. Given that the volume of cases in departments and states are often so many, so high, that it is bound to happen that these cases get to be treated in a very routinized manner. And I'll come to the number in my next slide. But here I want to make the point that it is inhuman and unreasonable to expect that every case and every affidavit will be given the due importance, and would be, while filing an affidavit, it will be made sure that there is no contradiction between departments and the case is filed as representing the views of the government. It doesn't happen that way. It really doesn't. And moreover, this gets even more complicated when the middle and the senior level officers, they avoid contributing to the file for fear of being hauled up. We know of cases where even chief secretaries have been hauled up and faced penal action. And therefore, it's not surprising. Of course, it's not justifiable, but I'm saying it's not surprising that some of them prefer not to even see it. Because once you have seen it, you know of it. And therefore, you have to sign on file. And therefore, you may be held responsible. And therefore, there are officers who I know do not even look at it, look at affidavits being filed, even in extremely important cases, because they say that they don't want to face the consequences of it. And that is sad. And then there is something which we call the RTI syndrome. I don't know how many of you in academics are aware of it. The RTI has done a lot of good things, but it has had some not so good things also. Due to the fear of visibility, officers avoid contributing, especially in the note files. I know a senior officer once told me that this habit of my writing on files and expressing my views so clearly could get me into trouble. And I said, why, sir? Why is it that I have to express it? Because that's why I'm there. He said, but look out. With RTI, anyone can get hold of that. And it's not just administratively and from the point of view of my service, but even otherwise, I could be in danger. So you see, that is how people have looked at RTI and its effect and its impact. That is the perspective from the official end. And I hope somebody does something about it. Because the fact that there are officers who are not writing on files because they are scared, I think that really impacts the governance and the quality of governance. And then there are the major cases that all very often fall into the maelstrom of adjournments, lack of continuity. An officer comes and goes. The cases are adjourned for up to 1 year, 2 years. An officer's tenure could be maybe 2 years or 3 years. And by the time he realizes what's happening in the case, he's gone. And therefore, it just does not get the right attention. Then there is legacy denial. And having served in a state like Kerala, I cannot but give you some examples here where the opposition leader, who had actually set up the action groups to not allow the drawing of cable connections, the high voltage cable connections, becomes the chief minister. What does he do? Does he allow? Does he change his views? He cannot, because his voters would not accept that. He would not be able to go and face them again. So he just dilly-dallies. He tries to put the blame on the officials. He tries to somehow manage without taking a decision. And that's how projects flounder. The high voltage cable lines in Kerala, which work was being done by the PGCIL for almost 8 years, could not find a way to be done, and the matter was lying in court. The PGCIL, Power Grid Corporation, actually went to court to find a solution. Even then, nothing could be done because few farmers, rubber farmers in Pathanamthitta and Kottayam, felt that they could not allow that to happen because it would harm their lands. It was not harming their lands, and even if it were harming them to some extent, they were getting compensation. And this was going to provide the power supply, provide the connectivity to Kerala from the Kudamkulam power plant, which I think was a shame. Then there are bad laws. There are bad laws. I think it's in a way, an oxymoron. A law cannot be bad, but there are bad laws. There are laws that are distinctly foul. And I want to give you the example of one case where the protection of the rights of the scheduled tribes, there was a law passed by a state that 20 acres of land was being given to the states, to every ST family identified who was landless, and he was supposed to be settled on that land. However, in the course of a few years, maybe a couple of years, those lands got alienated and they were bought up by resort owners, land mafia, etc., etc. The government passed an amendment to that act saying that all these transfers, which were actually illegal, are actually legal. They are legal because the people have bought it and they have already set up their activities on it, and therefore they should not be penalized because they've spent money on it. I thought that was an extremely bad law because they have bought the lands at a pittance from the scheduled tribes, making them landless once again and giving them false promises that their progenies, their children will get employment, which it never happens. And therefore, such an amendment was not called for. The scheduled tribes had nobody to represent them, and therefore the matter was lying in that manner. The more powerful, the purchasers went to court, went up to the Supreme Court, and surprise, surprise, the Supreme Court found that the law was proper. The law was legal. I think this is nothing but an example of a bad law. Because at the end of it, who suffered? It was the poorer families for whom the land was identified and was to be assigned. And the Supreme Court, to find via media, said that the state government will have to find alternate land and rehabilitate these ST families, which I thought was what happened in the end. If anyone is interested, I can tell you later, but not now. So this is the kind of bad laws that I had in mind. There is politics, there are paradoxical policies, there are trade-offs, and there is petty politicking. And who sits in the midst of it? It's the so-called the higher bureaucrats. And when the court comes in, it becomes an even more confusing matter. So it's a perfect petri dish for lax and non-responsive governance. In the next slide, I want to give examples that it's not just the executive, but it is also the other side, which has to be kept in mind. So any litigation can be seen from two ends. The spectrum has two ends. And let's look at the other end. There are litigations which are filed against the government policies, government projects, government orders, only as delay tactics. It's only a means to show power. We know in our country, a lot of the litigations are done, especially when it pertains to the non-movable properties, so to speak, are to show power. It's to show that I am socially more powerful, and therefore I can approach the court, and I'm also economically more powerful. I'm also class-wise more powerful. And that is why I can approach the court, where you cannot defeat me. And government really falls through the crack. Government cannot do anything in such cases. A person has a right, anyone has a right to go to court, and the government has to be a part of it. Government is made a part. But there is a more insidious aspect to it. It is also done to derail government policies and statutes. And there are umpteen number of cases which come to my mind, and where the government policy, an extremely good policy, which would have made a big difference in the lives of the people for whom they are targeted, at whom they are targeted, are actually kept in abeyance or kept in a state of undecided process only because somebody wants it to be derailed, and which is a sad thing. And I think a lot of it, and I know of a junior colleague who was once doing a work on this, that how much of the efforts of the government that are meant as welfare measures are actually derailed only because somebody has made up their mind that they will not allow it to happen. It's a large number of them, and we could talk on that. A lot of these can be actually a basis for future talks. Now there are interested parties that take advantage of the sheer ignorance of the public servants. As I said, public servants come and go. We are in one department one day, and within a couple of years, we are in another department. Who knows what's happening? Who knows the intricacies of the law in that are being handled and operated by that department? As an example, for instance, in the States, there are more than 100 laws that handle land issues. There are more than 80 laws that handle agricultural issues. Now, which state secretary would be able to read up and become adept at them before he can really take a stand on any of these court cases? Very few. And therefore, the interested parties take advantage of it. And then there is the lack of legacy knowledge. We know that we are so poor at keeping records. I'm reminded of what William Dalrymple says in his book, that a lot of the research that has happened even on our colonial times has been done by non-Indians. And the records are available not in Indian libraries and archives, but outside. Why is it so? I think we should have a system because we are so good at memory. We are so good at remembering things, even as a population, as a group. So why do we not keep records and study those records of our past government policies, projects, and implementation, and the problems that have arisen? We are very bad at doing it. Then litigation happens only to create confusion through multiple litigations. I know of a case which I was handling where there were 29 cases filed by the same party before the High Court, the Supreme Court, and the subsidiary courts, the subordinate courts, and the tribunals, Forest Tribunal, Water Tribunal, etc., etc. 29 cases. And every time the case came up, the file came up before me in the land reforms case, the reply given was that we do not have the original files, madam, because they are all submitted to certain court. Until when I said that I want all the files before me, it took us more than 8 months to get all the files together because we didn't know where the files were. Ultimately, we located them before a tribunal in Vaitiri, in Wayanad district in Kerala, and we got them all back. And how did we get it back? One of the deputy collectors in Wayanad actually had to go personally and pick them up. That's the situation. You see, nobody knew where the files were, where the records were. So it's normal for a person who is an interested party from the other end to create this confusion through multiple litigations. And there is nothing that we can do about it. Bureaucracy and public servants often are the scapegoats. We know it. When something goes wrong, who pays for it? The bureaucrat does, the civil servant does. May not be at the highest level, but at least the middle level or the lower level. The poor section officer is placed under suspension. Or the assistant, the poor assistant who had probably started the file is placed under suspension. And then the social media becomes a double-edged sword. We know how it can really cut both ways. I'll finish it quickly now. I want to spend just maybe 5 minutes on land-related issues in the next slide. You see, I am going into the land-related issues because land laws are the most abused. We have land acquisition, land assignment, land conservancy, land protection, land encroachment, and encroachment into water bodies. These are all land-related issues. And not surprisingly, and this is true, these figures are correct, 70% of the civil cases in our country are land-related. And in 80% of these cases, government is a party. Now, how do you avoid dealing with land under such circumstances? You have to, because it's so very important. In the higher courts, it is said that government is a party in more than half the cases, primarily through the writ petitions and the PILs. And who defends us in these cases? The public prosecutor and the government pleaders. And they happen to be often the weakest link. I will, since due to paucity of time, I will not go into it in detail now, but at the end of it, I will touch upon it. I have briefly mentioned a few cases, 4 of the cases which are land-related and which were much adjudicated. They started, many of them traveled right from the lowest court up to the highest apex court and took decades. But they cover areas which show how many people were actually to blame for the delay, for the misrepresentation, for the improper investigations, and how they actually ended up finally before the Supreme Court, before the highest court, and the orders were passed. And the last of these is MC Mehta's PILs, the 3 of them, on the concept of public trust. Again, I'm not going into it in detail, but maybe some other time we will have an opportunity to discuss it. What is the way forward? I have tried to put in the last slide, what is it that can be done in order to take us forward? I think some of you will recall that one of the concepts very close to Gandhiji's heart was the concept of Gram Adalats. It is true. I think that is one of the best solutions. And I say this because many of the cases that get adjudicated could be best solved at the gram level, at the village level. They pertain to water bodies, sharing of boundaries, encroaching on somebody's land, cattle theft. These are issues which impinge on the day-to-day life of the people. And they would be best solved at the panchayat level, at the gram level, at the village level. But even though it's been a government policy for the last, I think, 9 or 10 years now, that the gram adalats will be set up, the village courts will be set up. These will be proper courts and not any kind of kangaroo courts, proper courts which will be functioning at the village level with proper presiding judicial officers, and they will be adjudicating on cases based on law, the laws of the land. But these courts have been very slow in coming up. I wish they would come up and they get activated so that many of the cases could be sorted out there rather than going up to a much higher level. Second point I want to mention is something that is, I think, known to many of you, but often ignored. Are you aware that more than 30% of our investigating officers spend their time just ferrying under trial prisoners from the prisons to before the judicial officers, only because they have to be produced there every 4 weeks or 6 weeks. Now, 30% of them, 1/3 of them, if only they could be put into their regular work of investigation, how quickly could they file their final reports where the FIRs have been filed? It could be hastened, but it doesn't happen. And this could be avoided where the courts have now started doing is producing these under trial prisoners through video conferencing. So you free the police officers, you free the people who are actually wasting their time in going up and down, wasting time, creating pollution with all those bad vehicles, and the risk of the under trial being, leading to all kinds of criminal activities. The other point is the child-friendly and women-friendly courts. Delhi was one of the forerunners. Delhi High Court did it, and I was very fortunate to be involved in it in some way. And we have gone and replicated it in Kerala, and I think other states have also started doing it, where the cases are solved in a manner that is empathetic to the child or to the woman who is appearing. You have to understand that in civil cases, which are pending before the court, often the woman or the child doesn't even have a clue as to what is being said, what is being asked of her. And then on the basis of some question being asked, and she's held up for it, or she's punished for it, she's penalized for it, I think that's very unfair. And therefore we require the special courts and the special facilities that are necessary to interrogate and to produce children and women in courts, especially women who are not educated. In our country, there are a lot of them still, believe me. Depoliticize the selection of the government leaders and public prosecutors. I said that earlier. They are supposed to be the eyes and ears of the government, of the civil servants. But trust me, they are so ignorant, they wouldn't know what is being said. And second, and I have no hesitation in saying it because this is an academic discussion, one can clearly see and say that their allegiance lies not to the government, but to a political party. What do you do with them? Because as a bureaucrat, you are not part of any party. You're not defending a party. You are representing a government. But here is a man who refuses to speak what you have asked him to say, but he goes on to say things that are not meant to be said. And that has happened in umpteen number of cases. And that is an extremely sad part. And I can give an example, and I cannot but give an example, which is an example that I had kept in mind that I would mention it here. There is the case of a very long pending case in the High Court in Kerala, which is the case of it's called the Malayalam Plantation Company, which was then converted into the Harrison Malayalam Limited. It's a blatant case of a foreign company. Land was assigned to that company by the Maharaja in 1923. Post-independence, the company continued to hold that land illegally. Nobody said anything. In 60s, being scared that the FERA Act was coming and that the Land Reforms Act was coming in Kerala, they quickly transferred the land to a company in India, and which was illegal. They took nobody's permission. And the land continues to be illegally possessed by this company. It was very fortunate when I was there for a long period of time as Revenue Secretary. I got an extremely good government leader and AG, Advocate General. And we could take this case almost to its logical end. But believe me, we could not take it to its final end. And we had many reasons for that, which I will not go into it here. But I want to make the point that an executive, even if everything is okay, at the government level, at the executive level, at the political level, gets to almost to the end, there are hurdles thereafter. And the case is still pending. 60,000 acres of land, which actually belongs to the people of Kerala, is still being illegally held by a company which has no right to hold that land. But it is happening in a state which is so aware and so litigant. It still is happening. I also want to quickly mention that there are what the government can do and what the courts can do is place time limits at every stage. It is there to some extent in the amended CRPC, but it should be enforced, whether it is investigation, whether it is the trial, including the filing of responses by the government. And if it is not followed, fix accountability. Fix accountability on everyone. It should not be, on a chosen few. It should be on everyone. Whoever has defaulted should be accountable for it. I think that is what we need to do. It does not happen. And finally, make the elected representatives and officials also accountable for the delays. Because there are cases, again, I know of cases where files were actually lying in a minister's office for a full 5 years of his tenure. The file never came back. And then we say that who's responsible for the delay? Obviously, it is the secretary who's responsible. But the secretary was smart enough and kept sending a reminder every 3 months that the file is lying with the minister, and those papers were also added into the file. So you see, it's a hopeless case unless everyone learns. And the frivolous cases do provide backup support through the Constitution to the officials. But in the long run, it doesn't always do. And I want to end by, Nina is there, she would be aware of it. In 2008-9, when the High Court of Kerala, a judge, passed all kinds of strictures against the then Revenue Secretary, which I was, saying that I had not performed my duties, whereas I had actually performed my duties by taking over 26.3 acres of land in the heart of Kerala, in the heart of Trivandrum, which was illegally held by certain parties, a certain group of people, and it was done by the judge because he was an interested party. His son was a member of that club. So you see, and the strictures were passed against me. I had to go up to the Supreme Court to get those expunged. But then who protects you? Nobody looks at the Constitution, Article 311, and says, okay, you are free to go. You have not done anything wrong. There was nobody to say that, including my minister and the CM. So therefore, we are on our own at the end of the day. And therefore, we have to make sure that we perform our duties, and wherever possible, we force or impinge on the other side who is holding back something to perform their duties. I think that is also our responsibility. I want to conclude by saying that instilling a sense of duty in each of us is a necessity. Into the public servants at all levels, but also into our GPs, into our elected representatives, into our judicial officers, everyone. We all have to understand that we are performing our duties and we have to abide by the laws and regulations. We also have to avoid the political executive, the elected representatives, playing off one against the other. You know, traditionally, it is believed, for instance, that a land revenue secretary should not be on friendly terms with the forest secretary, at least officially. But why? And in Kerala, when I, as revenue secretary, I actually got to attend the meetings personally of the Minister of Forest, which were never being attended before. A junior officer would be sent. When I started attending them, we solved so many cases where the matter was pending only because there was a conflict between the land revenue and the forest department. We have to get over these, inexpressible contradictions. It just doesn't work that way. Whether it was FRA or CHR, so many cases were pending only because the land revenue department and the forest department would not see eye to eye. And finally, cases pending in courts are pending in courts, not always because there are vacancies of judicial officers, because we know that even the collegium, for instance, hasn't met for more than 8 months now, but for various other reasons. There are cases where senior judges are overlooked, competent judges are overlooked, because for various reasons. So you see, again, the discipline, that commitment to the good of the people is lacking. And that is causing the confusion and some misrepresentation. In conclusion, I want to mention that in social sciences, we have to be very careful. We are dealing with issues and people who are not amenable to being tested and tried out in a laboratory, unlike the natural sciences. We are dealing with ideas, we are dealing with concepts like empathy, like understanding, which is not there in the natural sciences. And therefore, there is sometimes the danger that we misinterpret coexistence or correlation as a causality. That should not happen. Something is coexisting with something doesn't mean that one is the cause of the other. That should not happen. And often that tends to happen in many of our social science researches. I want to just mention that fact. I think I've taken a lot of time. I'm grateful to Professor Madhushri that she's chairing this session, and I am open to any questions. And do forgive me if I've gone beyond my time. Thank you.
Thank you, ma'am. Thank you. It was wonderful hearing you and the insights that you have given regarding how we deal with our litigations and the whole issue of governance and accountability. It was a lot. It's highly informative. We'll come back with my understand at the end of the day. But I would now take this opportunity to invite our second panelist, Dr. Puneet. Dr. Puneet, we are very happy and honored to have him speak to all of us on this theme. Just to briefly introduce Dr. Puneet to the people, to the panel, to all here. Dr. Puneet is a faculty with at the Center for Study of Law and Governance at Jawaharlal Nehru University. He completed his education, that is his law degree and his PhD from Bangalore University, Mumbai, Karnataka. Before joining the center, he served as a faculty in the Indian Law Institute, which is a premier institute for legal research and higher education in law in the country since 2006. He also served as a member of Board of Studies and Academic Council of the Institute of Legal ILI. He had also been an assistant editor of the prestigious Journal of Indian Law Institute. His teaching and research areas of interest are constitution and administrative law, judicial processes, judicial administration, law and justice in a globalizing world, human rights, and criminal law. His doctoral work was on the topic of impact of global regulatory regime on Indian constitution. He is a regular contributor to the annual survey of Indian law and also published papers in a number of journals, both national and international. He has been an invited plenary speaker in a number of national conferences and has participated in many national and international seminars and conferences. He has delivered lectures at institutes and universities in India and has also taught at the National Law University, Delhi. Thank you, Dr. Puneet, for being with us and welcoming to share your thoughts on the topic.
Thank you very much for the kind introduction, madam, and a very good afternoon to all of you. Honorable Chair Madhusri Shekhar, distinguished co-panelist Dr. Nivedita Haran, discussant Kokila Konasinghe, invitees and other participants. I am very delighted to be part of this panel discussion. At the outset, I must thank Professor Amita Singh and other members of the NAPSI-PAC Disaster Research Group, particularly Binod and Gaurika, for giving me this opportunity. I must also compliment them for organizing this panel to discuss on one of the grave problems that is ailing the Indian judicial system. We have just heard Dr. Nivedita Haran, who made an excellent presentation highlighting how the government actually litigates. She, in a way, provided an insider's perspective. I'm going to speak on frivolous litigations in general as an outsider. As most of you may know, false, frivolous, vexatious, and unnecessary litigations have been clogging the wheels of justice for too long, making it difficult for courts and tribunals to provide easy and speedy access to justice to bona fide and needy litigants. It is said, justice delayed is justice denied. Most often we keep hearing about it. If that is true, and if one looks at the average pendency time of cases in India, which is 15 years, it can reasonably be concluded that in average number of cases in India, the justice is denied. Though there are many factors responsible for judicial pendency and delays, the frivolous and vexatious litigations are also largely contributing for it. In one of the cases where the Supreme Court has dealt with the problem of vexatious, frivolous, and speculative civil litigation in the country, the amicus curiae appointed to assist the court has in fact submitted before the court that 90% of the court time and resources are consumed in attending to uncalled for litigations in the country. What is more problematic, it is really alarming if 90% of the court's time and the resources are spent in attending to uncalled for litigation. What is more problematic is that even the governments, center and the state and their agencies, which are predominant litigants in the courts and tribunals, lack what is called litigative diligence and are often called out for filing or pursuing frivolous or vexatious and unnecessary litigations. It is often said that the state is the biggest litigant. I'm here using the word state in the sense in which it is defined under Article 12 to include both state and central government as well as all the agencies and autonomous bodies. So it is the biggest litigants, though there are no official resources to confirm the actual quantum of state litigation before the courts and tribunals. It is not in dispute that the state litigation constitutes nearly half of all the litigations in the Indian judiciary. The state should be a role model in all its endeavors, it is said. It should set ideals to be followed by others. Just as it is expected to be a model employer, it should also be a model and an ideal litigant. In reality, far from being a model and ideal litigant, the state has become a compulsive litigant. At times, it pursues litigation to win a case by hook or by crook against its own citizens or employees. In doing so, the state forgets the basic principle that it has the responsibility to protect the rights of the people, to respect the fundamental rights that are guaranteed under the Constitution. The apex court has reprimanded the state in many cases. There are very many cases where the Supreme Court has actually taken note of this vexatious cases that are filed or vexatious appeals that are filed before the Supreme Court. And in Dilbar Rai Jerry versus Union of India, it was one of the cases decided in 1970s. The apex court has in fact observed, I quote, "It must be remembered that the state is no ordinary party trying to win a case against one of its own citizens by hook or by crook. For the state's interest is to meet the honest claims, vindicate a substantial defense, and never to score a technical point or overreach a weaker party to avoid a just liability or to secure an unfair advantage, simply because legal devices provide such an opportunity. The state is a virtuous litigant, actually state is expected to be a virtuous litigant, and looks with unconcern on immoral forensic excess so that if one merits the case is weak, the government allows a willingness to settle the disputes outside the court, regardless of prestige or other lesser motivations, which move private parties to fight in court. That is what the Supreme Court has observed. Of course, the state does not have any such policy to pursue or win cases against its own citizens by hook or by crook. It is the bureaucracy or the political executive that are largely responsible for it. I'm not trying to say or point out that the bureaucracy as a whole is responsible, but certain elements in the bureaucracy are certain political executives that are responsible for filing of such false or frivolous cases too. Sometimes they take decision to go to court, as Supreme Court itself has noted, due to ego class or to save the officer's skin. That's the reality. More often it is found that utterly unsubstantial contentions are taken on behalf of the government and public sector undertakings. Even the repeated reprimands by the courts do not seem to have any significant positive effect on various government officials who continue to take decisions to file frivolous and vexatious appeals. And in one of the cases, the Supreme Court has actually noted the reasons for unwanted litigation by governments and statutory authorities. The court was of the opinion that basically such unwanted litigations by governments or statutory authorities stem from the two general baseless assumptions by their officers. One is they have an assumption that all claims against the governments or statutory authorities should be viewed as illegal and should be resisted and fought up to the highest court of the land. Second assumption is if taking a decision on an issue could be avoided, then it is prudent not to decide the issue and let the aggrieved party approach the court and secure a decision. That is what Dr. Nivedita has also pointed out, that there may be other reasons for the indecisiveness on the part of the bureaucracy. RTI and various other laws are there making them accountable. But if they can avoid decision, at least there are certain bureaucrats or even the political class who are not inclined to decide such matters, and because of which the citizens are forced to go to the court to seek appropriate remedies. The reluctance to take decisions, a tendency to challenge all orders against them, is not the policy of the government or the statutory authorities. This is what even the court has noted, but is attributable to some officers who are responsible for taking decision or officers in charge of the litigation. Their reluctance arises from an instinctive tendency to protect themselves against any future accusations of wrong decision making, or worse, of improper motives for any decision making. Unless their insecurities and fear is addressed, the Supreme Court is also noting that it is not a problem with a particular bureaucrat or the bureaucracy as such. They have certain insecurities, and unless that insecurities are also addressed, insecurities of the bureaucracy, they continue to do what they're doing to remain indecisive and force the citizens to get what they're otherwise entitled to through courts or tribunals. So these are the two important assumptions that the bureaucracy actually has, because of which these vexatious suits or appeals are being filed by the governments. The vexatious and frivolous litigations, apart from clogging the justice delivery system, also drains the state exchequer. The cost of litigation, if one looks at that, is incurred by different departments of the governments or the different autonomous bodies, including the universities in the country, which are otherwise facing fund scarcity for meeting the legitimate requirements, are also spending a lot of money on the litigations too. So it drains the state exchequer, it consumes the executive times too, and it also makes citizens to incur avoidable expenditure too, because if what they're otherwise entitled to are denied at the first instance by the executive authorities, then they're forced to go to the court. So they are also made to incur avoidable expenditure. Particularly when the state files vexatious and frivolous appeals, it causes delay in allowing the successful litigants to reap the fruits of the judgments rendered by the courts below. It is a matter of serious concern and it must be addressed. But before proceeding to discuss how it is sought to be addressed and the effectiveness of the measures taken, let me also point out two other aspects relating to the state litigation. One is with regard to the inordinate delays in filing appeals or applications. This is one of the serious problems. The case appeals as such may not be frivolous in some cases, but the state at times approaches the court after an expiry of the limitation period and seeks the condonation of delay on flimsy grounds. Recently, as recent as in the last month, the Supreme Court has castigated the state. In that particular case, it was the Haryana Urban Development Authority, which has filed an appeal before the Supreme Court after the lapse of 4 years. The Supreme Court has castigated, saying that the state cannot behave as if the law of limitation does not apply to it, and imposed a penalty in that particular case, penalty not on the authority as such, the Haryana Urban Development Authority, but on the concerned officers for the delay in filing the appeal. That is one important aspect, that the state, it is generally, there are no research work to substantiate this claim, but someone who is familiar with the court proceedings, it is somewhat it is somewhat known, very well known among, of course, the litigating lawyers who face states as respondent, that they often file appeals long after the expiry of the limitation period. As once the limitation period expires, the rights that are granted by the courts below should stand crystallized, and the party who got the decree in the favor should be allowed to reap the benefit out of it. But the state delays in filing appeal, and then thinking that the courts, sometimes the courts are also easily condone the delay if the delay is on the part of the state. Taking advantage of that, after long delays, appeals are filed, and in some cases, the Supreme Court has reacted to it. So that's also another important problem that needs to be looked into. And the further problem is the interdepartmental disputes between the two different departments of the state or the central governments, are between different public sector undertakings, are between the public sector undertakings and the government departments. Such disputes are also often come up before the courts. Such interdepartmental disputes are detrimental to the public interest. In one of the cases, the Supreme Court has said that it was not contemplated by the framers of the Constitution or even under the Code of Civil Procedure that two departments of a state or a union of India will fight litigation in a court of law against each other. It is neither appropriate nor permissible for two departments of a state or the Union of India to fight litigation in a courts of law. Indeed, such a course can be detrimental to the public interest, as it is also entails avoidable wastage of public money and time. So that is also another important problem with regard to the government litigations as such. With this, let me move on to how to deal with the problem of excesses and frivolous litigation. It is wrong to assume that there is no realization at the level of policymakers to curtail unwarranted government litigation. There are many deliberations on this in the past. There was a national policy and state litigation award at Conference of Law Ministers of India in 1957. Similar deliberations have taken place in the conference that was held in 1972 as well. And in 1973, the Law Commission of India in its 54th report has addressed. It has actually taken note of the problem and then recommended certain measures to be taken to avoid frivolous and vexatious litigation by the state. And the 126th report of the Law Commission of India submitted in 1988 has also dealt with this problem. They, in fact, in that particular report, made adverse comments upon the reckless manner in which the appeals are filed routinely by the state. And in 2010, there was a national litigation policy that was formulated with a view to transform the government into a responsible and efficient litigant. But it was not implemented. These are the measures that are taken, are deliberations that are held at the government level, at the policy making level. In addition, the Supreme Court has also, in certain way, tried to resolve the problem by imposing cost on the state. In certain cases where the filing of appeals is found to be ex facie frivolous or delay is caused by the negligence on the part of the officers concerned, the cost is imposed on the concerned officer directly. It is because as long as the cost comes from the government's coffers, it does not prevent the officers from making irresponsible, reckless, or callous decision to pursue vexatious or frivolous litigations. So that's the reason why in some cases the court has directly imposed cost on the officers who are responsible for making such decisions to file appeals. There was a recent case where in the state of Punjab, a departmental inquiry was initiated against an officer long after his retirement, notwithstanding the specific provision in the service law that no such departmental inquiry can be ordered against a retired officer after the 4 years of their retirement. Notwithstanding this clear, explicit statutory stipulation, the department initiated an inquiry nearly after 6 years of retirement of the concerned officer, and the concerned officer went to the High Court. High Court quashed the departmental proceedings, but then the department filed a intra-court appeal before the division bench of the High Court. Division bench of the High Court also did not find any merit in the department appeal that was filed, and it imposed a cost on the department for pursuing such a litigation, even though there is a clear stipulation under the statute. And since the division bench of the High Court has imposed a cost on the department, they filed an appeal before the Supreme Court. And the Supreme Court, after castigating the approach adopted by the department, upheld the order of the division bench and then said the concerned officer must pay for it, and we are not going to interfere with the decision of the division bench of the High Court. So, but these are exceptional cases where such drastic measures or harsh measures are taken to discourage frivolous, vexatious litigations that are being pursued by the government. That is one important measure that the courts are often resorting to discourage it. Another important measure, or rather the suggestion that was made by the court in some cases to deal with this problem is about parliamentary social audit for wasteful litigative expenditure. In some of the cases, in 2 cases at least that I've come across, the Supreme Court has recommended that there must be parliamentary social audit about the wasteful litigative expenditure. Perhaps that is an important suggestion that should be taken serious note of. And such audits shall be conducted not just in the parliament, even with regard to the litigative practices by the autonomous bodies, like the public sector undertakings or any corporations or even universities for that matter. There shall be a regular auditing that is done to see, how many cases actually the government departments or the autonomous bodies are actually winning, or in how many cases the citizens are actually getting relief. If that is so, then it is the indecisiveness of the concerned authorities that is responsible for forcing the citizens to go to the court. And if such auditing reveals any indecisiveness or a modified intent because of which there is an inaction on the part of the concerned authorities, then they shall be squarely held responsible. So, but the piecemeal attempts are not going to help in resolving what has now become a gigantic and a perennial problem. If the government is a major litigant, on the one hand, the government is trying to address the problem of judicial delays and pendency, and also government is trying to provide access to the citizen, access to courts, access to justice to the citizens by providing for legal aid and all. And on the other hand, by denying their statutory entitlements, are denying their rights, the government is forcing them to go to the court. So these two things needs to be looked at. They are like the conflicting policies of the government in a way. So this has become a gigantic and a perennial problem. If one does the Google search about frivolous litigations in the Supreme Court, there are so many judgments that are passed by the Supreme Court. I could find when I was searching for it yesterday in the evening on the SEC online database that consists of the Supreme Court and High Court cases, I came across with nearly 3,000 cases where the Supreme Court and the High Courts have dealt with frivolous cases. Not necessarily all of them are frivolous litigations by the state, but I'm sure substantial chunk of them are from the state because the state is the biggest litigant. So these piecemeal attempts to resolve the problem is not going to help. We need to deal with it comprehensively and holistically. And we need to have a national and state litigation policies, both at the national level as well as the state level. And the national litigation policy of 2010 that was adopted, or rather announced by the law ministry, was not implemented. It was a policy which was more abstract, and many have criticized, saying that it was not implementable. But even if it was implemented to some extent, at least some of the problems which Dr. Nivedita Aran has pointed out of how the government conducts the litigation, how senior officers do not even look at the affidavits and all. The National Litigation Policy of 2010 has actually addressed some of those problems. Even if it was implemented, it would have actually gone to some extent in addressing this problem of excessive and frivolous litigation by the court. So, but it was announced and it was not implemented. The government of India in 2015 claimed that it is revising it, and then it would come up with the new national litigation policy, which would be more comprehensive and holistic. But so far, no progress has been made. I'm of the opinion that if at all this problem needs to be addressed, what is more important is to have a national litigation policy. The government should finalize the national litigation policy and operationalize it sooner, which should provide broad guidelines or lay down broad principles as to what kind of litigation the government should fight, under what circumstances, for what purposes the appeal shall be filed, and what kind of litigations should be avoidable, and how the decision to pursue the case further should be made at what level, and accountability, if any, that needs to be fixed, should also be dealt with in such national litigation policy. I think when I say we need a national litigation policy, the national litigation policy should lay down at least the broad principles or guidelines. It need not deal with each and every aspect of the litigation. It need not be entirely detailed, because that should be left, in my opinion, to the concerned departments. Once the national litigation policy is formulated, each department of the government, each autonomous bodies or public sector undertaking should be required to formulate their own litigation policy, looking into the specific kinds of cases that they handle. They should be allowed to formulate litigation policy, which should be in conformity with the broad principles and guidelines laid down the national litigation policy. Just as if you look at, all of you are familiar with, I assume, with the Disaster Management Act, where there is a national disaster management policy and the state disaster management policy and district level policy. In addition to that, each department of the government are also expected to formulate their own policy. So taking clue from that, I'm suggesting that there must be a national litigation policy. In addition to that, all the supplementary details should be put in place by the concerned departments by formulating their own litigation policies. And even the states should also undertake a similar exercise and formulate the litigation policy. And in my opinion, that is the first step towards addressing this gigantic problem of frivolous and vexatious litigation by the state. And only if such policies are formulated and strictly adhered to in all litigative practices of the state, that government can truly emerge as a model or ideal litigator and cast away its existing tag of being a reckless and a callous litigator. But another important point before I conclude is that when we think of having a national level litigation policy, we must take stock of the existing litigative practices of the state. What kind of litigations the state, different departments of the state are fighting. There must be a survey and an auditing of it to understand the problems. If you were to, we all know that the government is a biggest litigant, but there are no government's records that actually tell us the quantum of government litigations. Government does not even have the records of how many cases the government is fighting. Even if you ask the law ministry in the central government, that what's the percentage of pending cases in which the government is a litigant, either as an appellant or as a respondent in cases. So the government has no details about the existing number of cases where it is one of the parties, and what kind of cases are actually lost before the court, and in what kind of cases the government has a reasonable the chances of succeeding in the case. All this needs to be taken into account. And there are kind of cases where the government is repeatedly losing the case before the court, but despite of that, the government goes to the court again and again. There was a recent case, not very recent, it was in 2018, that the government has filed set of appeals, group of appeals before the Supreme Court, raising certain questions of law, which question of law is already decided by the Supreme Court in the past, and the Supreme Court has dismissed all of them together. And then the government again came up with another set of petitions raising the similar question of law and filed it before the Supreme Court. Even in that case, the Supreme Court has imposed cost on the government. So it's important for the policy makers at the time of formulating a national litigation policy to look at all these cases and look at least the cases where the Supreme Court has taken serious note of vexatious or frivolous the cases filed by the government, and what kind of orders or strictures that are passed, so that there can be a better understanding of the problem, and an effective litigation policy can be formulated to deal with that. So I end here with that, and I look forward for any questions or comments on what I said. Thank you very much. I thank once again Professor Amita Singh for giving me this opportunity.
Thank you very much, Dr. Puneet, for that very, very informed talk which you gave, and with so many examples of cases and also reports, and also the initiatives that can be taken to deal with frivolous, and as you referred to the word, is gigantic and perennial problem facing our judicial system. And it was really wonderful to hear from you also that you spoke about the two sides of the spectrum, both sides of the issues here of both the cases of judiciary, what problems are faced by the bureaucrats, and also in getting justice and reaching the cases for the people for whom it is meant for, and how the justice system is getting derailed because of these cases. And you very importantly pointed out that that the state is it is wrong to assume that the state has not taken is not realizing this problem, and state is taking a lot of initiatives, and also the issue of the topic you suggested is that parliamentary social audit of wasteful expenditure. These are very, very important highlights and points you have pointed out regarding strengthening the governance structure around the judiciary and litigation. Thank you very much, Dr. Puneet, for the talk. I would like to take this opportunity now to welcome our third very important speaker on this panel today, Professor Kokila Konasinghe. Briefly to introduce Professor Kokila to the speaker, to the gathering here, August gathering here, that Professor Kokila is a professor of law in the Faculty of Law at University of Colombo, Sri Lanka, where she currently teaches human rights law and environmental law. She was heading the International Collaborations Office of University of Colombo and was also the academic coordinator of distance learning diploma in human rights and democracy at the Center for Study of Human Rights, and coordinator of executive diploma in human rights at the Faculty of Graduate Studies of University of Colombo. Her research interests are in north-south dimensions in environmental governance, cultural relativism and universality of human rights, disaster management related studies, and law and literature. She's an attorney at the at the Supreme Court of Sri Lanka, and has received her LLB degree from the University of Colombo, and was an LLM degree from Erasmus University, Rotterdam. Her PhD is from Kiel University, United Kingdom. Madam, we are very happy and honored to have you speak to us here. Welcome you. Ma'am, you're muted. You're muted.
Thank you. Am I audible now?
Yes.
Okay, I go on. Thank you so much for the introduction. And I think I was invited as the discussant for the forum. So I think I'm expected to give few comments on the previous speakers. After two most, not only intellectually, but also practically and very politically engaged discussions, it is my honor and privilege to highlight few of the significant comments of the topic on frivolous litigation and executive accountability to the Constitution. I praise NATSIPAC Disaster Research Group for the lecture series conducted on various dimensions of law and governance, which are the two pillars that uphold justice, equality, and fairness that are so focal for any human being living in this so-called unit called society or a country. Before I move on to the two presentations by excellent presentations by Dr. Nivedita and Professor Puneet, very well researched and very well presented. I quite enjoyed listening to both of you. Let me share some interesting background to this discussion on my own findings. The Daily Guardian, published on 2nd January 2021, reported an interesting piece of writing by Professor Amita Singh. She very strongly expresses her views as follows, which actually inspired me to accept this invitation to contribute to this discussion. I quote, "The law may play a crucial role in building a nation, but ethics, morality, and integrity plays a wider role that brings the much required flywheel to the stagnation of law." I unquote. Failure and delay is not only from the part of the judiciary, it is well within the parameters of executive, administrative, legislative functioning as well. The injustice can be occurred actively in the form of a violation as well as inactively in the form of an omission. I quote the Daily Guardian article again. Let me quote. Pensions, retirements, benefits, gratuity, and leave encashments are not issues on which the administrators need to push an employee to courts for seeking justice. It is bureaucratic default mode now practiced with audacity and insensitivity. How brilliantly, Professor Amita Singh, you explain and you open up the dialogue of all this administrative malfunction lead to many more areas of delay and inappropriate functioning of justice. So thank you for that valuable contribution, and I quite enjoyed reading that, and it inspired me to make these few comments. Many concepts and principles comes to my mind when I discuss and when I join this discussion, this forum. Separation of powers and check and balance theories, and most importantly, public trust doctrine. I heard that Professor Nivedita also mentioned this as a very important point in this regard, and I would like to highlight few points on public trust doctrine principle. According to Mahavansa, the written history of Sri Lanka, in 223 BC in Sri Lanka, when the king Devanampiya was on a hunting trip, the Arahat Mahinda, son of the Emperor Ashoka the Great, preached to him the below sermon during his diplomatic visit to Sri Lanka on a religious mission of Buddhism. I quote, "O great king, the birds of the air and the beasts have an equal right to live and move about in any part of the land as thou. The land belongs to the people and all living beings. Thou art only the guardian of it." What I am talking about was preached in this South Asian part of the world in 223 BC. So in South Asia particularly, we have a rich history of protecting the interest of the public. So the public servants, government servants, civil servants, all of these concepts were the legacy of the British colonial mechanism, but we have to remember and we have to reiterate the significance of our historical heritage of public policies and public governance rules, which highlight the public trust doctrine. And this explains the great theory of public trust doctrine. The rulers, administrators are bound by the principle of accountability and legitimacy to deliver their service to the best interest of the people of the country. The duties of the civil servants and the government officers should follow the will of the citizens. The moment the trustee violate the expectations of the beneficiaries, who are the citizens of a particular country, he or she will be violating the divine principle of accountability under the public trust doctrine. In the US, the Declaration of Independence has the following inspirational words. This quote, when I was reading around to collect few information for this talk, I came across these very inspirational words. Now, in the US Declaration of Independence, it states these words, I quote, "We hold these truths to be self-evident, that all men are created equal that they are endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. So in 1984, in the movie called Protocol, actress Goldie Hawn pointed these lines. Let me read out that. The revolutionaries who founded our government wanted to protect their liberty, and they wanted the government that would allow them to be happy. When was the last time you thought about happiness and government in the same sentence? So this opened up the debate of the government, public servants, and what is the role of the public servant towards ensuring happiness and liberty and independence of the country of a free world. Let me now highlight a few points of Dr. Nivedita's ideas presented. With her diverse experience, I always admire listening to her and experience and knowledge. She explained the role of civil servants. Some drawbacks on the role of administrators were emphasized, such as RTI syndrome, higher volume of cases to be handled on daily basis, lack of continuity that may lead to lack of faith in administrative system, non-responsive governance mechanism. Litigation can be seen from two ends. Litigation that fight against the government policies, bad laws and regulations, and the next one is to show power, social, political, economic, class, sectoral power. People come out with litigation. So also lack of legacy knowledge is also very interesting finding that Dr. Nivedita pointed out. And I was quite fascinated by that idea. For researchers and academics like ourselves, maybe this is something that we should highlight upon our future research and findings. And also, she further notes latest challenges posed by the social media upon administrative functioning. Her way forward remarks were also something that I also share the same ideas on this. We should strengthen the role of the grassroots level public administration, such as Gram Adlat. In Sri Lanka, we call Grama Niladhari. So the role of Grama Niladhari and also these village courts play a vital role in emphasizing and establishing justice at a society. I share similar ideas in the Sri Lankan context. Many of the cases and issues can be dealt effectively as well as efficiently at the local level rather than going up to the superior court level. Very important, and this is a very sustainable reform, such as make elected representatives accountable for delays in response and non-responsive. She also suggested to make the officers accountable for the expenses of the delay in justice, which actually a brilliant idea. This particular idea of Dr. Nivedita brings my attention to Vilpakku judgment recently decided by the Court of Appeal in Sri Lanka on 16th of November 2020 against the illegal settlement of internally displaced persons inside a reserved forest. This demonstrates an impressive application of polluter pays principle in extremely broad terms, recognizing and affixing liability on the polluter to restore the environment into its previous condition. The Honorable Judges of the Court of Appeal issued a writ of certiorari and mandamus making a former minister, Rishad Baduddin, accountable for illegal resettlement of villagers in a national sanctuary during his office era. His decision to clearing out the nature reserve called Vilpakku caused much deforestation and destruction by totally violating provisions of the Forest Ordinance. He is now liable to pay all the expenses for the reforestation on the whole area of forest cover out of his own money. So this set a good precedent for those who take ultra-virus decisions, those who go against violating the provisions of law, without going beyond the parameters of the power territory, now are subjected to pay back out of their own money if there is any expenses or public money expenditure. Professor Puneet, on the other hand, highlighted the role of the government and courts to protect the interest of the litigants. Supreme Court also is with the opinion, according to him, for these frivolous cases should be discouraged. Professor Puneet stressed the waste of public money on unnecessary litigation. And also he highlighted the two major concerns of these frivolous cases are delay in justice, and also interdepartmental disputes are detrimental to public interest. It is legally inappropriate to entire system of delivery of justice as well as unnecessary expenditure of public money over these litigations. So both speakers were with the opinion that existing administrative mechanism should be revisited by a holistic approach based on concepts of principles of justice, equity, and fairness. And also, we have to reinvent the wheel on civil servants and the role of public officers. Based on what would fit into our soils, rather than going behind the British legacy anymore, because there are certain things like this Grama Adalat or Grama Niradhari in Sri Lanka, strengthening their role would be a very effective and efficient mechanism. So with that note, I conclude my talk, my points to this discussion, and look forward to join the question and answer session. Thank you so much, and thank you, Professor Amita Singh, for giving me this opportunity. Thank you.
Thank you, Professor Kokila, for that excellent bringing out the highlights of the two talks that were given by the two very prestigious talks. And you very, very rightly pinned out the points which were highlights of the two talks. You emphasized, and from your discussion presentation it's very important that we also learn from the lessons around our country, around us in the subcontinent. And you referred to the Grama Niladharis, which are very insightful experience and the learnings that we could do, and highlighted what Dr. Nivedita was emphasizing on strengthening of the Gram Adalats. It's always important that local initiatives should be strengthened, local governance needed to be strengthened to deal with litigations or issues that concern the lives of the local people. That's a very, very important highlight you mentioned. And you also re-emphasized the role of looking at the role of government, and which was highlighted by Dr. Puneet's presentation, and you very, very importantly said that it was very interesting and to hear from you that existing administrative mechanisms should be revisited, and we need to reinvent the role of bureaucracy to strengthen and deal with the vexatious litigations and the problems of litigation. Thank you very much, Dr. Kokila, for this very, very insightful rounding up of the two excellent lectures. And I now I would like to open up the discussions that were there, and I think Dr. Gorika, would you be taking it forward?
Yes, ma'am. I request Binod to please take some of the questions that have appeared in the chat box.
Yes. If some pressing questions are there, they can ask Gorika. One or two we can directly take. Otherwise, I will directly move to the questions which have appeared in the chat box. If anybody, any participants wanting to directly connect to our panel of speaker, they can directly connect to the speaker. But only request is that please keep your question brief, because we are already running out of time.
We request Professor Amita to speak a few lines, because we all start from the paper the points she had raised in the newspaper articles, and it would be very nice to have Professor Amita speak a few points before we open up for all the other questions.
Sure, ma'am. Sure.
Thank you so much. Ma'am, for you, ma'am.
Well,
thank you very much, Madhushri. This debate is one of the most powerful and one of the floodgate to ideas. And I'm just shocked with so much happening, and the three important, speakers coming here together, each one picking up a different strand of, the problem. And I think feeling very happy today that we've been able to put this discussion through today, and hopefully this would be carried further in the researches of students working in law and governance, in administration, and in related areas. So congratulations to all the speakers, Dr. Nivedita Haran, Dr. Puneet, and Professor Kokhila. Excellent, really. I'm really having a number of other ideas also now coming in, but let's start with the questions right now, because some of the questions are really good. I'm looking at that, and before our speakers get their clock stopped, we must put them to answering some of the questions. We need the knowledge that they have. Thank you. Thank you.
thank you, ma'am. Thank you. So I'll be, if somebody can connect, they can connect, or otherwise I will start the question which has already appeared on the chat box, because 2-3 questions are very pressing, which I can see on the chat box. Directly pointed questions are there. The first questions which is there on the chat box is that by the Professor Ravin Bhattacharya for Nivedita ma'am, regarding the village adalats. And the question is, are village authorities competent enough to deal with landlords sitting in the village adalat? All cases then will again be referred to the established court, just delaying the issue. Ma'am, can you reflect on the questions of
Yes, please.
Can I 1 second
yes.
Just intervene here? Bangladesh has a very good work on land laws management at the local level. So if there's anyone from Bangladesh, just allow somebody.
Sure.
After Nivedita ji has spoken.
Okay. Thank you. Yes, the kind of cases that arise at the local level are disputes, civil cases, disputes pertaining to land, water, pathway, vegetation, etc., or property related. These are the major disputes that arise at the village level. And I think if anyone has the competence to handle such cases and such laws, it is at the village level, because they will not only be knowing the local situation, but they will also be trained in handling the laws of the land. And therefore, I don't see anything amiss in that. In fact, if anything, I feel that they would be able to handle those better. Thank you.
Okay, ma'am. Thank you. Can somebody from Bangladesh, because they are already participating, can I request them if they want to connect, and if they can give some reflection on the discussion from the Bangladesh? Okay.
Yeah, thank you, Professor Amita Singh, and thank you, 3 speakers also. Really, they are presenting very knowledgeable and practical things related with the land management. I have some, I have something, I don't know anyone from Bangladesh or not, but I am from Bangladesh. That there is a village court in Bangladesh also, we call village level court. And the village court is capable enough if the situation is allowed, because you know that in local level administration, there is a magistrate and local court also. if the village court is capable enough, then they and the panchayat or the people are those who are the landlord or the who are the victim, they are agree with the opinion of the local leader and the local administration, that can be solved in the local level. If they're not agree, and they can go to the higher level, also higher court. And most of the cases, they try to minimize in the local level, because village people or rural level people are try to avoid the higher level court, but normally they can solve the problem in the village level. You know, they in local level, they know each other, and they know their problem, and they are try to minimize the problem in local level. Normally they are try to minimize, but or in 100% case they are become successful. That's not true, but most of the cases they are become successful to solve the problem in the local level.
Thank you, ma'am. Thank you. For the next question is for Dr. Puneet, sir. And the question is, how PIL, public interest litigation, contributes to frivolous and vexatious legal proceedings, and what are the ways out? And this question has been asked by Devi Parvati. So please, sir.
Thank you. It is in fact a very good question. But as far as the PALs are concerned, generally, it is not filed by the state, it is filed against the state. It is filed by citizens or other litigants against the state. And if one looks at the history of public interest litigation, it was to provide access to those who otherwise do not have access to the courts. No resources or a possibility of approaching the court on their own, even in the wake of grave injustices that are done to them. But over a period of time, the trend has completely changed, and public interest litigation, which even Professor Bakshi calls it a social action litigation, which is the appropriate phrase in my opinion, has turned into what is now called a publicity interest litigation. The kind of things that are taken to the court in the name of public interest litigations are very strange, and now the PAL is actually being used as an instrument against the poor and oppressed in some cases, whereas it was invented to provide access to justice to those class of citizens. And in some cases, the courts have also imposed cost on the frivolous public interest litigations that are filed. But as regards what approach the state can have towards the PIL, keeping in view the current trends also in the public interest litigation, this is an aspect that has also been looked into and specifically provided for in the National Litigation Policy of 2010, the one that was adopted that I mentioned before. And there are like 4 important points as to how to deal with them. Number one, it is of course keeping in view the trends in the public interest litigation, recent trends in the publication, is that PIL should not be taken as a matter of convenience to let the courts to do what government finds inconvenient. That is also what is happening now. That if there are certain things which the government find it inconvenient to do, there are litigants who maybe at the behest of the state approach the court to file a public interest litigation and ask the courts to do what the government find it inconvenient to do. At times, the courts also try to do things which are impermissible for the government to do. The National Litigation Policy says it should not be done. And if you look at the state responses in some cases, sometimes based on the state is a respondent, of course, in all such cases, but based on the submissions that are made by the respondent state in some of the PLs, pushing forward the cause in which the government itself is very much interested, it seems that the government does not even resist such public interest litigations at all, because government also at times is very much interested. I'm not talking about any particular government, either in the union or in the state. It is the practice general that is found for the last many years too. That is one important aspect. Second, the National Litigation Policy says it is recognized that increase in PL stems from a perception that there is a governmental inaction. You know, even if you look at the early definitions of judicial activism in India, Subhas Kashyap, Dr. Subhas Kashyap says, judicial activism is something that is born as a correction to the failure or inaction of the government to provide clean, competent, and citizen-friendly governance. It is the government which has failed, so that the judiciary is stepping in, and mainly through the public interest litigation. There is this perception that the executive or sometimes even the legislatures have failed to deliver, and that's why the public interest litigations are being filed. And the national litigation policy has suggested that such perception needs to be changed in the first place. That's the second important aspect. Third, it says it must be recognized that several PALs are filed for collateral reasons, including publicity and at the instance of the third parties. This is what I guess even Dr. Professor Amita Singh also pointed out in a piece in the Daily Guardian, when she said the fun litigation is taking the place of cause litigation. People now go to the courts for various reasons which have no public interest to be served at all. They have someone goes to the court saying that the national anthem should be sung at every film theater. I don't know whose fundamental right they seek to enforce. Somebody goes to the court and file a petition saying that no, these courts are not sufficient. We should create one more court in between the High Court and the Supreme Court. So establish a national. That requires a drastic amendment to the Constitution. Can any citizen go to the court, seek a direction to the Parliament to amend the Constitution? So there are the list is endless. Anyone, I think today that parliamentary system is not working well in India and presidential system should come. Can I go to the court and file a PAL asking the court to give direction to the state to consider it? This is all crazy. This has become like a fun litigation, as Professor Amita Singh has rightly pointed out. And the fourth and the last point that they've dealt with in the national litigation policy is that PLs challenging public contracts must be seriously defended. That is what I think Dr. Nivedita Aran also was pointing out during her presentation. If interim orders are passed stopping such projects, then appropriate conditions must be insisted upon for the petitioners to pay compensation if the PIL is ultimately rejected. So this is the government's strategy. Perhaps some of them, if actually adopted, might help in addressing the problem of excessive petitions. India, if there are any questions, I'm willing to take.
Thank you, Shad. Last question which I am going to take, because we are already passing of time. The last question is from Amita Singh, and this is the Vigilance Department in districts helping and collaborating investigations? This is the question. Yes, to Nivedita ma'am.
Actually, you see, the vigilance structure is independent from the police structure, and it does not have officers up to the village level. So just as you have police stations for law and order, there is no police station for vigilance cases. So in that sense, the village does not have the presence of the vigilance. That is true. That's a very good point. In fact, you've set me thinking that maybe there is, if the vigilance is active and agile at the village level, maybe a lot of cases could be detected much before they actually happen. So there is a point in what you say. Yeah, I think you have set my grey matter working. Thank you. Although I haven't answered your question totally.
No, Dr. Vinod, can I come in?
Yes, ma'am. Yes.
I just wanted to talk to on the point which is just spoken with Professor Amita Singh's question and Dr. Haran's reply. It just made me thinking, ma'am, is that we do have, for example, the vigilance committees under the PDS of food distribution systems, which are set up at the village level. And these are user committees, vigilance committees, and there's a total de-link, So if you're talking about vigilance system, as you said, it's missing at the local level. So having such user committees, which are named as vigilance committees, how does this function in the governance structure at the local level, I was just wondering about that, because there's a total de-link.
Yeah. So, actually, yes, if I can just mention something,
yes.
Professor Madhushri. I think vigilance is being used, quote unquote, vigilance is being used in two separate meanings here.
Yeah.
These vigilance committees you're talking about do not have the powers to investigate and also find somebody, even to take punitive action. They do not have those powers. It's actually a watch committee rather than a vigilance committee.
Yeah.
Whereas the vigilance in the sense of the CVC vigilance is something very different.
Yeah. I was just wondered because, you know, you have the title given as a vigilance committee and it has no teeth around it, you know, it just tells you what corruption is happening or not happening, you know. So, and then there's a very big misnomer happening around there in the local governance structure. If you start looking at only have these vigilance committees and without having given them any statutory role or action.
Yeah. If I can also add, Professor Madhushri, on this point, something new has been coming up, and maybe that is worth emulating, especially in the externally aided projects. The partners are insisting that every project implemented there should be a third-party auditing. And that will ensure that there is an amount of vigilance in that. And in the third-party auditing, the actual stakeholders, the beneficiaries, would also have a say. I think that brings in a bit of, overriding engagement of the actual beneficiaries. And that is probably the point that you're raising. And I think that is a good thing. From my personal experience, I feel that engaging and having third-party auditing is an extremely good thing because it goes into the issues of procurement, of implementation, of quality of the project, etc., etc. And that is exactly how we can avoid corrupt practices and thereby reduce court cases.
Yeah.
Thank you.
Thank you. Thank you.
Thank you, ma'am.
One last, you know, this is a suggestion, you know, I'm just very curious to ask Puneet. Can we suggest something like this out of this discussion that we had today, that as judges graduate from the session court to the district and, you know, higher up high court and Supreme Court, you know, shouldn't they have refresher courses through a very legitimate judicial academy where they are put to discussions like this so their mind opens up and they're not confined to the courtrooms, because all they have till the time they reach Supreme Court, majority of them are very confined to the courtroom. They don't know that they're disconnected with the society. And you know, if they were vigilant enough, the frivolous litigation could have stopped right in the beginning. Look at JNU, for example. You know, that is something, my triggering point for writing that article. You know, this kind of a game which is going on and on and on, eating out all the funds of the university, you know, starving research in the university. You know, this is happening because of the frivolous litigation. Now, who's responsible? If the judges were, you know, vigilant enough, they could have imposed fines upon the lawyer who is repeatedly, you know, enslaved by the executive authority to carry that bundle to the court, which is not required. So, you know, can we have a suggestion coming out of this, and we'll put it on our website? What do you think about it? I want to know the legal point of it.
No, yes, madam. See, the point is, as far as the judicial training is concerned, generally the trial court judges undergo training periodically, though it is not like a mandate. There are national judicial academy at Bhopal, and each state has a judicial academy and their own. And the judges periodically attend some kind of a program. Maybe that should be institutionalized in the first place. Number one. Two, that under the existing laws itself, like if you look at the civil litigation side of it, under section 35 of the CPC, the court has a power to impose caste against the frivolous litigants. And the caste can be imposed the power even against the state when it files the frivolous cases or appeals. And the Supreme Court time and again has also reminded the lower court to use its power under section 35 of the CPC to to impose such caste. Maybe in the judicial training that you're suggesting, it is already going on. One thing is that it should be institutionalized so that periodically judges should be made to go. What is lacking is that the higher court judges do not go for any such. That's where my concern, and they only go there to teach and enlighten the subordinate judges, and not generally to learn so much. There are honorable exceptions, of course, but that is the. So, in my opinion, at every level, the judges should be made to, like, if a judge is appointed to the High Court, there must be a mandatory induction training. When he is appointed as a Chief Justice of an High Court, again there must, because the role and functions and duties are different. When they come to the Supreme Court jurisdictions are entirely different from the High Court decision, the jurisdiction. So they should further be made to undergo training. That's one side of it. Second, as regards vexatious cases, apart from training the judges as to how to deal with them, it is also important to train the government officers and bureaucrats about the cases and how the decisions will be made. And what are the laws that are already settled concerning the department, so that if similar issues that arise, they should not actually file. Dr. Niveditaran was also pointing out that when bureaucrats transfer from one department to another department, they cannot easily familiarize themselves with all the laws that are being administered by a particular department. So there must be a training that is given to them, at least by the experts, saying that these are the things, and these are the existing litigations, these are the issues that this department has raised, and these issues are sorted out in this way, so that if similar issue comes, they should not unnecessarily create a situation where individuals are compelled to go to the court. So the training for those bureaucrats or officers in the litigation department is also most important in my opinion.
So shouldn't we also suggest something like, the Right to Information Act, so right against frivolous litigation if individual penalties are imposed against officers, because, administrators would not feel free to prevent a frivolous litigation if the political executive is pushing it forward.
Yeah, no, that's what, madam. It's not about only blaming the bureaucracy as such. Sometimes they act at the behest of the higher ups. So we need to know on whom the responsibilities shall be fixed. So the political executive should also be, that's what the parliamentary social audit should actually look into the responsibilities of the ministers. What they have made, did they encourage a particular petition and all that? Because the ministers as such, the Council of Ministers, collectively responsible to the Parliament. So they should also be made answerable there, and should not be always allowed to blame it on the bureaucrats or the, as Dr. Niveditaran pointed out, on the lower level of officers, like a section officer, clerks who are in charge should not be troubled because of that. So responsibility should be fixed elsewhere. That includes the ministers of the department in certain cases.
Excellent.
Amitaji,
thank you.
Sorry, Binod, just
yes,
one
ma'am.
sentence.
Yes, ma'am. Yeah.
Amitaji, on RTI and the RTI syndrome I mentioned, actually the matter was taken up to the courts, the high courts, that the note sheets should not be, the note file should not be made public. And some of the high courts allowed that, if I remember. But then in one case, the matter went up to the apex court and it was disallowed. So therefore, there is some kind of a, confusion on that now. But in general, note files are also accessible to the parties as of now. That is the decision.
May I just comment, madam, on RTI
Yes,
Act?
please. Yes, please.
There are accepting the exceptions provided under Section 8 or so of the RTI Act, which does not include file notings in all cases. So file notings is accessible under the RTI, which is a right. If there are high courts that have actually exempted them, then the high courts are completely wrong, in my opinion. Going by I'm not saying what is right and what is wrong, going by what the existing statute is, RTI Act, the file notings are accessible. Otherwise, what happens, only the decision is made accessible. That is in any case communicated to the general public. What is the point of having a RTI Act? So I have applied for some benefit, whether it is provided or rejected, I will be communicated. There is no right in accessing that. It's about what led to that particular decision to be made. Should be made accessible. If you take out the file noting from the RTI. Maybe RTI is being abused. That is a different problem that needs to be fixed. I entirely agree. And it is actually imposing a lot of burden on the administration. Sometimes we have seen that it is overburdened the administration, which are functioning with a skeletal staff. But if you take out file notings from the RTI, then RTI only remains in skeletal form without much significance to it. That's what I feel.
Okay, sir. Thank you. The one last question which I wanted to ask is from Chetan Chauhan. And this question is, how can we increase legal awareness to common people in rural areas in relation to frivolous litigation? So I invite a panel of experts to look at this question and reflect on that.
Since time is short and everyone is in a hurry to go, I'll answer in one sentence, Chetan. Educate the public. Literacy, starting with literacy, and then you come to other forms of education. When you have illiterate public, and I have seen the women where I'm living now in UP, not aware of their rights because they don't even read the newspaper. They can't even read things that are shown on TV. So literacy, literacy, literacy. That's the answer.
End.
Thank you, ma'am. Thank you.
Thank you, Vinod. So without wasting much time, I would request Debhuti to please deliver the vote of thanks.
Chair's last comments.
No, I would.
Coming up.
I have enjoyed, and I just don't have any more comments to say because it has been so.
I would like to hear from you.
No, because the 2 or 3 points that struck me together was that it's very important that we have this problem. Number one, I would take off from the 3 talks is strengthen the institutions, reinvent, go back to the institutions, strengthen institutional arrangements for dealing with this, particularly strengthen local government and local governance institutions to bring in people's voices. Second is to try and ensure that we have audits built into that so that we do not, so that the problem of vexatious litigations and this can be dealt with. And most importantly, which was pointed out by all the speakers, is that learn from all of us, because all of us, all the countries around us, we have lessons that are happening. Because as part of NAPCPAC, I would just not like to say that what we are doing in India, but it's important that we also learn from what is happening around us. We have excellent lessons from Sri Lanka, from Bangladesh, as was pointed out, and that makes us forward to look at it and learn from these institutional structures which are there and build those institutions to make governance more responsive and more strong at dealing with such issues. Ma'am, that's all I would like to say. And I would just keep myself brief at this point. Thank you, ma'am.
Thank you so much, ma'am, for wonderfully summing up the entire session. I now request Debhuti to please give the vote of thanks.
Thank you, Gaurika. We are extremely grateful to our eminent speakers for today, Dr. Nivedita Haran, Dr. Puneet, for enriching us with one of the most important themes, that is the justice delivery. Special thanks to Dr. Kokila for rounding up and joining us from Colombo, and warm gratitude towards our chair for steering this session, Professor Shekhar. Thank you so much, everybody. And a big thank you to the technical support that we have every time from Jitender and Ibrahim ji. Finally, to the wonderful audience who joined us for this session. And lastly, to the NDRG team of academicians, administrator, mass media, and field researchers. Thank you. Good afternoon, everybody. Stay safe and healthy. Thank you so much.
Thank you so much. Thank you. Thank you so much.
Thank you very much.
Thank you.
Thank you.